So we would like to welcome those of you who are following us on Zoom. There is a interpretation, simultaneous interpretation, French and English. Those of you who want to listen English and French. I think most of the presentations will be made in French. I would like to apologize, present apologies for Alexander Fanta from Net Gazette from Germany. He comes from investigating newspaper. He's the first one who raised this problem of the text messages between Mrs. von der Leyen and the Pfizer laboratories on the third contract. Well, and he sent his apologies because he has lost a member of his family. So he has asked me to proceed. First of all, I would like to explain what the MEPs have done. This is quite a long story. COVID started December 2019, officially declared pandemic in January 2020. And very soon, at the level of the European Commission, it was decided to have grouped purchases. So, because they believed that all the member states should have access to the vaccines, which was a good reason, so that no one will be privileged, and so that the poor countries would not be discriminated against through these bulk purchases. So the European Parliament was seized to vote a budget in April 2020 of 2.1 billion euros. So for this bulk anticipated purchases, so to support the labs, to do all the research work, to develop vaccines. And in November, when the commissioner in charge of health at the European Commission mentioned that some contracts were negotiated with 6 labs at the beginning, and we ask for transparency around this contract, because some EU citizens approached us and said, in case of a vaccine, because back then no vaccine was developed, the citizens said, we want to know exactly the clause, if there are secondary effects and so on, who will be able to seize in case of problems. And so these were the first questions on the transparency, the production side, who will produce and how. So we were approached by the European citizens for more transparency around the contracts. So the commissioner in charge of health said, you will have access to the contracts. On January the 11th, the Commission has, presented the CureVac contract to the MEPs, because CureVac agreed to provide the vaccines. So we looked at this confidential document. We were not allowed to invite legal experts to examine the contract. So this was all confidential. But we saw that the contract was redacted. So, parts of the contract were blacked out. And so we received this unredacted version, but the full contract was not available on January the 20th. So we, for the first time, asked to have access to this contract. So a group of 6 Greens, one from Luxembourg, Margaret from Denmark, Jutta from Germany, myself, and Kim Ireland. So a group of countries through their MEPs asked to have access to the document. So the Commission, really was not answering our questions. And June the 30th, we received a negative reply from the Commission. So we said we will continue really to request this to have access. So the group of the 6 MEPs have reiterated their request. And then when we saw that there was no reply, or complaint was lodged. So January the 20th, we sent a letter to Mrs. von der Leyen to ask a series of information, the price to be paid, the number of doses to be supplied by quarterly, so intellectual property, non-exclusive license, the compensation in case of damages and side effects due to the vaccine, the access to the vaccines in Europe. So following that, a COVID committee was created, but we still don't know what are the stocks of vaccines in the different countries, the developing countries, what have they received. So we have only part of the information, but we don't have a full table with the information about the volumes of vaccines available. So we have seized the European Court of Justice to have access to this contract. And this is valid not only for this contract, but this is also for future contract, which is going to really link in the future the European agency to pharmaceutical companies in the future. If public money and European taxpayers' money is given to companies, I think it is important that we receive the information. So the third contract with Pfizer and Mr. FANTA came up with the information. 1.8 million doses were allocated through a contract of 35 billion euros. So, and the first contract was 15 euros per doses, and now we have increased to 19.5 euros per doses. So I'm welcoming more participants, says Madame Rivasi. I was just explaining the complaint we lodged, the request we put to receive access to this contract. And through the initiative of Alexander Fanta, a German journalist who unfortunately could not be here for personal reasons, well, he actually has used an information published by the New York Times, and this is a very important publication. Mrs. Kriakides said there have never been SMSs. There is no SMSGate. It's not true, because the New York Times has really published this information that there has been an exchange of text messages between Mrs. von der Leyen and Mr. Bola, and they had excellent contact. The journalists wanted to have access to these text messages. The Commission's first reply was there are no text messages, and then it was, but these text messages cannot be publicly accessible. So he brought this to the Ombudsman, but these are just recommendations. So the Ombudsman examined the dossier, and so according to her, she said that the text messages, this SMS, are official documents like emails and any other, and that a lot of information is circulating through text messages. So there is the reply of the Commission was wrong. And this is the current situation as far as access to these text messages is concerned. So since the information was published by New York Times, so they have, following this, they have seized the European Court of Justice. So there have been two really actions lodged ourselves because we have no access to the contract, and the second one to the Court of Justice. We want to have access to these SMSs, to these text messages. So this is the current situation. What else could I add? Someone is making a observation of the mic, sorry. So no, we are waiting for the reply of the European Court of Justice. As far as the texts are concerned, we know that the European Public Prosecutor's Office, and I am a member of the Budgetary Supervision Committee, and they told me that actually there have never been before so many requests and complaints from European citizens on issues of transparencies of this contract. So 3 judges of different countries have been seized with complaints, but we'll see what the European public prosecutors will do. But as you can see, so the European citizens are not, challenging the principle of vaccination. No, what they are here challenging is the non-compliance with the principle of transparency of and the contract. The first contract, June 18, 2020, the European Commission signed a contract with the 25 member states. So an agreement which is allowing the Commission on behalf of these 25 member states to sign this contract and do bulk purchases. And so this is the contract which is linking the Commission and the laboratories. And I'm saying this because, as you can see, the Ombudsman has been seized, but the Court of Auditors and and I'm a member of the Budget Committee. Well, the Court of Auditor examined all the documents. They went to the Commission, DG Health, DG Santé. Well, they give them access to all documents, the steering committee, and also the documents of the scientists negotiating the recipes for the vaccines and the doses. And if you look at the report of the Court of Auditors, they will tell you in the last contract, there is nothing, no document from the steering committee. So no scientific negotiation, we have no information. There is not even a minutes on the number of doses which should be supplied and so on. The Court of Auditors said there is a problem. We don't have access of the information, and there is no compliance with all the EU rules. When the contract was signed in June 2020, it was stipulated that teams of negotiators had to be set up and a steering committee.
Mrs. Ursula von der Leyen is not competent to sign these contracts on her own. It is the reason why those those text messages are so important, because if she sent text messages to order 1 billion doses, well, we got the last information recently about the third contract. It was not up to her to decide. So she went beyond her duties. And the price increased. It upped from 15 to 19 euros in the third contract, because it was 35 billion when the vaccines cost 15.5, but it skyrocketed. And it's very important because there was a clause in this third contract and not in the others that forced the member states to buy those vaccines. And we will look later on at the clauses of the third one. But Pfizer didn't let go. Pfizer still wanted to sell the doses to the member states. But with the pressure of the Commission, states such as Hungary and Poland didn't sign the additional clause of the contract because Pfizer said, we are going to reduce the number of doses to 170 million doses. And the member states can sell them again for 10 euros. So in France, for example, we had to buy 10 million. That was compulsory. Out of the 900 million doses, 450 were used in 2020. But in 2023, we still have 450 million doses left. And there is a quota for each country. So it's been postponed to 2027, but there are 70 million doses over 4 years that will be shared between 4 states. Pfizer accepted that a number of doses could be paid 10 euros, even though we didn't wanted it. We didn't want them, even though Pfizer is not going to produce them, but they want some form of compensation to account for the flexibility price-wise. So there are still 70 million doses that should be purchased at the price of 10 euros a doses. And that stems from the negotiation between Ursula von der Leyen and Albert Bourla. But the member states signed. 2 states didn't sign only, Poland and Hungary, because Poland says, I'm welcoming Ukrainians, I need money. Why am I going to pay for doses which I'm not going to use? I prefer using that money to welcome the Ukrainians. And the Hungarians said, well, we're not interested either. And the Commission told these 2 states that they should negotiate directly with Pfizer. That's the situation. So the contract was protracted until 2027, when it extended. Validity of the contract was extended to 2027. Minus 70 million cancelled, but it means 70 million doses a year for 4 years. And the European Drug Agency, Medicine Agency, said in the future, even in the future, if there is another pandemic, Pfizer would have the monopoly of providing vaccines. So Europe has signed to become completely dependent on Pfizer. So we had the European Court of Justice, Europe, the European MEPs, and the New York Times about transparency. And now I would like to give the floor to Frédéric BALDAN, because you filed a complaint to the criminal court, and I would like to give you the floor. Let you speak, because I think you have given more reasons for the motives. So my question is, as citizens, why have you lodged a complaint to the criminal court. I would like to congratulate you for your action as an MEP, because not all MEPs do the same. I would like really to thank you and some of your colleagues. You really are defending general interests. Well, I realized how absurd the situation was. For example, the text messages. We have an offense in Belgium, which is arbitrary infringement of the rights and liberties guaranteed by the Constitution by a public office holder or a civil servant. And I found myself in a case in which I thought, well, either Mrs. van der Leyen still has those text messages, so she's infringing the fundamental rights of transparency, and it is an arbitrary infringement. So it is a criminal offense. Either she destroyed those text messages, and in that case, it is a destruction of administrative documents, which is also a criminal offense. So I came to the conclusion that it's quite simple. We are in a case in which we can suppose there are several offenses. First of all, she negotiated with her close friends, Mr. Bourla, by granting his friend and his company a monopoly on the European market that was not part of her jurisdiction. So that's an offense. She overstepped her duties by using a prerogative that is the member states' prerogatives. And we also have corruption and the illegal taking of interest. She was not acting in favor of public interest. There's no doubt about that. So I filed a complaint to an examining magistrate in Belgium. I thought nobody was going there, nobody was doing that, and I decided to do it myself, to file a complaint against Mrs. van der Leyen. So we're having a discussion now about the jurisdiction that is competent, but it's a bit complicated because the Belgian prosecutor's office thinks it is part of a jurisdiction of the EPPO, European Public Prosecutor's Office. In my opinion, it is not really the case because I'm a Belgian victim of the violation of a national interest, while the EPPO has the duty of defending the interests of European institutions, but they have nothing to do with a European victim. I cannot file a complaint to the EPPO, for example. And we realize that it is something that has been ill-designed in the design of the EPPO. The European Prosecutor's Office thinks that they have no legal deadline before they answer the Belgian judiciary's question. And that's a violation of my right too. So they should seize the phone that was used to exchange those text messages, for example. If the text messages are still there, an offense will be noted. And if she destroyed those text messages, there will be an opinion given to the investigative magistrate saying that those text messages was destroyed. And I took another conservatory measure when we see the lie of Mrs. The person who lied and said that Mrs. van der Leyen had nothing to do with those negotiations. It's a shameful lie. And I came to the conclusion that if Mrs. van der Leyen stays in her position, she can harm the investigation. She can also destroy other documents, and she could influence the civil servants and other members of the European Commission. So you may remember the Santerre Commission's lawyer at the end of the 1990s. There was also an issue with the Commission at the time. It was the Jacques Santerre. Jacques Santerre was the president. There were auditing reports that said that even if a commissioner said he was not aware of a fraud organized by his administration, he was responsible, he or she was responsible because it meant he or she had lost the control of his or her administration. That then in the European Union Journal, so it has it is binding, an ethical code, ethics code for European commissioners was published, and I realized that Mrs. van der Leyen had clearly violated the provisions of this code of ethics. So I filed a complaint to the European Court of Justice. Mrs. van der Leyen is not a politician that's been elected by the people and who represents the people. In the action of the court, there is no attack against the separation of powers, but what I'm asking for is the immediate suspension of Mrs. van der Leyen and other European commissioners. Because if we don't do it as a conservatory measure, after they have lost any notion of public ethics, they can harm the investigation. So as civil servants, they should be set apart for the time of the investigation. If at the end, the conclusion is, or the decision that everything was normal, well, I'm doubtful about that, but why not? And in that case, they can be reinstated. But here, in this case, the level of infringement of fundamental rights is so high that it's no longer possible to defend that position. Mrs. Rivasi said it in yesterday's interview. Collectively, without exchanging opinions, Mr. FANTA, the New York Times, Mrs. Rivasi and her colleagues, the other MEPs and myself, have filed complaints before almost all jurisdictions, all the courts. We have started all the possible proceedings against Mrs. von der Leyen. I can't understand how the Commission is still protecting her and publicly ignoring the questions asked by the MEPs. The Commission is not answering those questions. Even though we have alerted the media, the criminal court information was hidden in certain countries while published very clearly in other countries, in about 20 countries in 20 languages. In Belgium, in the French, the Belgian agency, in the French press, among others. And we don't understand how the European Commission, the so-called democratic European Commission, is not reacting. She's pretending it does not exist. I don't know if it's a communication strategy, but anyway, it is unacceptable. They are responsible, and they should accept that responsibility. Acting in that way shows their scorn for fundamental rights. The Charter of Fundamental Rights has the value of a treaty, and the Court of Justice is of the opinion that it has a constitutional value. Only a few MEPs have shown that they take very much to heart those democratic principles and those fundamental rights, and that's very challenging. That's a serious issue. So we are telling them, are you still in favor of the separation of powers, and are you going to take action? That's what we're saying to the justice system. And are the institutions accountable? Are they going to be forced to comply with the European Charter of Fundamental Rights? I'm really grateful for your fight. We're not interested. We don't really care about the party you belong to. I mean, you could be of any party. It's just your struggle for democracy, and we can support you because you're acting in defense of a general interest. Thank you.
As you know, we have created a special COVID committee. So we thought that this would give us access to information. Well, it was a horrible procedure, no access to information. So we had, some of the directors of the pharmaceutical laboratories came, others did not come. And, we have asked Pfizer not to be accepted to come to the parliament. And at the conference of the president, this request was turned down. We asked for Mrs. van der Leyen for the Leyen to come, because the committees, did not know how to answer all the questions. So we need to have a counterpart, the president of the European Commission, and she declined our invitation. She did not accept to come and explain. The political parties decided to convene a conference of presidents, but nothing has happened. This is why I organized this press conference today. Like Mr. BALDAN said, it's unacceptable. I'm an MEP. I'm here representing the general interest at European level. So we have voted to allocate public money or money to buy vaccines. We agreed in principle. However, we need a full transparency of contracts. We need to know what is the liability of the companies vis-a-vis the European citizens. And what we ask is an explanation from Mrs. von der Leyen, why she had bypassed the steering committee, the scientific committee, so 4.5 billion doses have been ordered for 71 million euros. And today there is no request, no for doses, vaccines, no more pandemic, and we are forced to buy this vaccines. So I think there has been a problem somewhere. I would like her to come and tell us, okay, I made a mistake. Okay, things got out of control because you had AstraZeneca. They prefer to supply the Brits and the Australians. What I want for her is to give us an explanation. I could understand that things got out of control because we were in an emergency situation. Well, but this is not the first time it happens. It happened already when she was the defense minister, when she had also signed contracts through SMSs, these text messages. And in Germany, she had to really explain herself. What we want is for her to come and explain the situation. And the fact that she doesn't come, and, if the special COVID committee has no access to information, what is the purpose then? And this is really undermine the legitimacy of our institutions. And to come back to the COVID committee, they have actually done some work, and I think they have really provided some information. Mrs. Jaleswo from Pfizer actually have she has recognized that the labs had never really made studies on the capacity to stop the transmission of the COVID. And we can see that this is really an arbitrary decision. We are not here challenging scientific studies. No, the governments did not have any scientific studies, so they could not to support their decision. And thanks to your committee, we have that information. And Mrs. Galina told us that they knew that from a legal point of view, they could not act in this way, but she didn't care about legal aspects. And we have a video of this. And, and actually that's why the young people in her departure liked her. This is quite incredible, because the role and the task of the European Commission is to really safeguard the treaty. And here I have someone from the Commission saying, actually, she's willing to violate the treaties. She should never have said it officially, but the Commission is really supporting this type of behavior. So my question is, has the Commission decided to really violate and not respect the treaty? I will use the treaties to support my action. We are entitled to have access to the documents. So we took this to the courts. However, how long will it take for the courts to do something? So the Belgian prosecutor's office replied to you that they have to really contact the European prosecutor's office. So what is going to happen? How long will this take? And I know we have different NGOs attending this conference. I would like to give them the floor. Yes, please. Rachel, could you introduce yourself? Rachel Anna. So access to European funds from the NGO. Thank you very much for attending this conference. You have quite a global, comprehensive information as to the access to the European information.
Yes, I'm Rachel HANNA, and I'm Deputy Director of Access Info Europe. And we are an organisation that focuses on the promotion and the protection of the right to information, both at the EU level and globally. At the EU level, we work very closely with Regulation 1049, which is the law that governs the right of access to documents, to EU documents. And therefore, we see firsthand the weaknesses of this regulation, both on paper and in practice. It must be kept in mind that Regulation 1049 was actually adopted 20 years ago. And since then, we've seen major technological advances. Ways of communicating have changed, and so too have the way decisions are made. However, having said that, while things have changed, the actual definition of a document under this regulation is still adaptable today. It says that a document is any content, whatever its medium, relating to policies, activities, and decisions falling within the institution's sphere of responsibility. Therefore, if we actually just look at the letter of the law, technically a text message is a document that falls under Regulation 1049 and therefore is in the possession of the institutions, depending on its content. However, as we've seen from this recent case, the Commission doesn't exactly share this view. This was made evident when journalist Alexander FANTA requested under Regulation 1049 access to text messages exchanged between the Commission President and the CEO of Pfizer on the purchase of COVID vaccines. The Commission stated that due to the short-lived and ephemeral nature of text messages, they are not documents that fall within its registration policy. They therefore are not technically in the possession of the Commission, do not fall under Regulation 1049, and cannot be requested by the public. This interpretation of the law by the Commission goes completely against the spirit of Regulation 1049, which aims to give citizens the widest possible access to documents. Alexander then took a complaint to the Ombudsman based on this decision, and the Ombudsman decided that this was maladministration. The Ombudsman made it clear that it's the content of the document and not its form that matters here. She stated that texts do fall under Regulation 1049, and the Commission cannot rely on the argument that just because it does not hold these text messages due to its registration policy, that we cannot access them via 1049. In response to this complaint, the Ombudsman recommended that the Commission search again for the text messages, making it clear that the search should not be limited to the documents that fall within its registration policy. However, as we know, Ombudsman recommendations aren't binding, and the Commission has stated that the way in which it handled this request was justified and followed established practices. In an attempt to get a binding decision, the New York Times has jumped on this case, and after submitting a similar request, which was also denied, the New York Times is now taking the Commission to the European Court of Justice, arguing that text messages are indeed EU documents that are in the possession of the Commission. So why does this even matter? If we agree that text messages are indeed documents, then the Commission's interpretation of Regulation 1049 allows for the avoidance of the obligation to record official documents. We have seen in numerous other EU countries specific scandals regarding the deletion of text messages by decision makers, and we're now also seeing this excuse of short-lived ephemeral documents being used regarding the access to emails. This approach not only denies the public its fundamental right of access to EU documents, slowly chipping away at public trust, but it also puts at risk the preservation of official recording of decision making. This could have been an opportunity for the Commission to tackle this issue of instant messages being used by decision makers and to set a positive example for the national level. However, instead, it's chosen to undermine both the Ombudsman's decision and the right of access to EU documents. And according to the Ombudsman's own words, has given the regrettable impression of an EU institution that is not forthcoming on matters of significant public interest. The fact that we're even all here today really does show that there is public interest in the update of the currently flawed EU access to document system. However, in order to ensure accountability of decision making in this information age, we need to tackle this issue of instant messaging under 1049, and we also need political will from all institutions to do so. Thanks very much.
Merci.
Thank you. I would give the floor Christophe VAN GHELUWE from the Belgian NGO. So could you please introduce yourself and present your NGO? Good morning. Thank you for your information. I represent the NGO, which is advocating transparency for all public offices and also transparency of administrative documents. So this is why I fully agree on your position on the importance of transparency at EU level. In Belgium, for example, the government is reviewing the legislation on the transparency of documents. And this is a legislation which dates back to 30 years ago. And due to the latest developments in communication, means of communication, we would have expected for this legislation to be updated much earlier, especially when fighting corruption and opacity of we see today that the health crisis is actually triggered the whole process. The governments are closing up like an oyster. Sorry for the comparison I'm making, but yes, following the health crisis, we can see that the institutions are closing up in Belgium, and the civil society, the citizens are more informed. They demand more access to information. On the other hand, we have the authorities which are closing up and not providing this information. And I think there is a huge risk for our democracy and undermining our democracy. And I think this is why it is fundamental to really make some progress on this principle of transparency, and also to update legislation and make sure that we do enforce the legislation, because we can see that sometimes there is legislation and as my colleague just said, yes, text messages are covered by this regulation. And so Article 32 of our Constitution really does present the scope of access to public documents, and and non-compliance is a criminal offense. And I think it is important because we can see today that the way Europe is perceived, the Commission is perceived through this SMSGate is really bad with the election, and I think it is important that the European communities and the authorities do something and make sure that they do not really undermine these principles.
Est-ce que il y a Médecins du Monde, vous voulez prendre la parole? Alors,
Voilà.
Oui. Je vous remercie, Médecins du Monde vous remercie pour l'action qui est menée ici aujourd'hui. Alors, notre
We are very worried that doctors of the world about intellectual property rights and access to medicine. Today, we find ourselves in a situation of vulnerability because we are dependent on Pfizer. And there are patents that seem to justify the monopoly given to Pfizer. But the patent applications of these companies, of BioNTech specifically, to the European Patents Office, well, how to explain it? There is a phase in the patent application procedure that is kept secret. And at some point, the patent application is published. And that patent application was published at the end of 2021. And it was only then that we could be informed of the characteristics of those patents. And we used a tool that any citizen may use, and that's a tool for third-party observation. It's a support to the examination of the patent. Any citizen can do it, can observe the criteria on which the patent application is based. And what we wanted to challenge was precisely that. We put forward very good arguments, putting into question the patent application and the activity of BioNTech. Well, there is an examination that takes place before the patent is granted, and the examining officials said that indeed BioNTech had to reword their application, and were very focused on that. We pay a lot of attention to that because we know that the intellectual property issue puts companies in a very strong situation in negotiations. So important elements could have been taken into account in the negotiation. The price, for example, because if there is no transparency, we think there can be no fair price. And several NGOs think like us. And that are working on the issue of the transparency of the price of medicines in Europe. And that action takes place in the framework of the resolution on transparency of the WTO, which we support. And we would like to see all this reflected at the European level. So we're now waiting for the results. And we're going to follow that very closely together with our European allies. Is there anyone here from Global Health Advocates? I'm sorry, but the interpreter cannot. It's very difficult to translate that because the sound is very low. We're Action Santé Mondiale. We're an NGO based in France. We're also present in Brussels, and we work on fostering the transparency of pharmaceutical companies and the contracts between those pharmaceutical companies and the member states. So we published two reports titled Access Denied. When pharmaceutical companies are sitting on the right-hand side of the driver's seat. And this report shows what you have described and what we have seen during these last years, and these absolutely opaque relationships between the European Commission and pharmaceutical companies. As Juliana from Doctors of the World said, we work in a consortium in France too. to make sure that the relationships between public authorities and companies, corporations are transparent, contracts, relationships, prices. So we thank you very heartily for your decisive action in that field, and we hope that at the European level it will be making progress, and also in France. In France, there are discussions about that. We see that there are attempts at bringing back pharmaceutical companies to France and Europe, but that strategy should not be a blank check strategy. That strategy should also provide for transparency conditions, environmental protection conditions, among others. Thank you. Just before we wind up on this part, before giving the floor to the journalists, I would like to give you a piece of information that I find disturbing, and I really need the NGOs. We have insisted a lot about transparency, and everybody agreed. All the political groups agreed, apart from the Conservatives. But we just heard that the European Commission has been lobbying incredibly strongly the elected politicians, among which the socialists. And as to the request to have access to the contracts and future contracts, they have removed things that seem to us absolutely essential. I'm going to read to you a compromise that will be published. Ask the Commission to publish the full draft of the purchasing contracts for the attention of the general public after the date of their termination, whenever it is legally possible. That's astounding. What does that mean? When that is legally possible. They have always told us we cannot give you all the elements of the additional clauses to the contract. They were saying we're waiting for all the contracts to be signed, and then we will give them to you. But when many parts were blacked out when we were given the contracts, and we let them do that. And I need the NGOs and I need your action, your support to tell the European Parliament and socialist MEPs that they should not accept that. In the Charter of Fundamental Rights, there is a very specific right, which is the ban on rights abuse. So the authorities cannot invoke a right to remove another one. So the Commission is opposing the right of a private third party against general interest. Transparency should protect the public interest and not the interest of the labs. It's unacceptable to think that Pfizer, as a private company, would have rights as a supplier that would be higher on the scale of rights than those of the citizens. It is unacceptable. I'm not going to vote in favor of that text, of course, but there was such a lobbying by ERA, among others, saying, well, with Pfizer, negotiations with Pfizer, don't be too demanding as regards transparency. But why do something that is less than what we demand about transparency? And why has the contract been, and in addition, the contract has been signed, the operation has taken place. Where it is the risk in terms of competition for Pfizer? The contract is signed. It doesn't involve unfair competition risks for Pfizer. And from the point of view of the business law, it's a total scandal. But I'll tell you that it is a daily fight. The more we speak about transparency, and I'm really concerned about that, the less there is transparency. And we should always be fighting for transparency. We are always about everything. When we see what happens about pesticides in the field of research, it must be public interest that prevails and not private interests. We're not asking them for the recipe of the vaccines. We're asking for information that are of interest for European citizens. And we need to be really on the watch as European MPs and citizens together and their organization. If in the final report there is that sentence, even in the price increase, there's something disturbing. They were paid for research and development. The American army helped them for logistics and production. There was no need for marketing because it was a pre-order. It was pre-ordered before it was produced. So no need to have stocks. What has it cost to the pharmaceutical industry? It cost them €2 according to certain estimates, and they sell them €20 a piece. So they are not taking any risk. They are not paying the costs. The contract is an open breach of the public interest. Taxpayers' money pay for everything, and all the profit is for the industry. And in France, there is a special tax legislation. There can be research tax credit. So you can get public money, again, by having had European aid finance your research. The interpreter apologizes, but it's impossible to translate this. Way too low.
Alors, vous vous présentez, s'il vous plaît. Oui, oui. Parce que...
moi, je suis musicien, enfin, mais en fait... Ah, d'accord, d'accord. Mais en fait, même si pitié mais en fait, je suis quand même mandataire d'un parti politique, enfin plus de Pélos. Donc on était vraiment sur la politique sanitaire. On n'a pas le temps.
Ouais. Alors, est-ce qu'il y a des journalistes qui ont des questions à poser? On en parlera. Oui, allez-y.
Are there journalists who would like to ask questions? Please go ahead. I'm sorry, I can't hear enough. You filed your complaint about 2 months ago. And in the Le Vif Belgian magazine, there was a paper saying that it was in the limbo. As you say, it is Judge Frene, the investigation magistrate. No, it's more at the level of the public prosecution. Can they hear me? It is a question of jurisdiction that should be decided before the investigation. So by signing up to the EPPO, the state accepts to delegate prior to the EPPO, which responsibility is to say whether or not it is part of their jurisdiction. And after that, the National Prosecutor's Office can decide whatever they want to do with the opinion given by the EPPO. It's somehow like a no man's land. Sorry, the sound is not loud enough. What I was saying, well, the European Public Prosecutor's Office answered that they didn't have to meet any deadline to respond to the Belgian Prosecutor's Office. Well, the Belgian Prosecutor's Office has to ask for their wait for their response before taking action. And this brings me to Article 47 of the Charter of Fundamental Rights of the European Union. Well, this text has the value of a treaty. As a citizen, I'm entitled to an effective action, legal action. So I cannot be forced to accept an unlimited duration. The complaint is a 13-page complaint. A reader of Le Vif magazine can read it in an hour, and they are surprised to find out that after 1 month, there has been, or 2 months, there has been no answer from the EPPO. That is an infringement of the Charter of the Fundamental Rights. The text that says there is no deadline. Well, that approach of the EPPO is not legal. It is not in compliance with the treaty. I hope I have answered your question. We will hear the question. The interpreter apologizes, the sound is too low.
Alors, si vous voulez, c'est des considérations un peu compliquées parce qu'on a...
These are complicated considerations because we were not really facing before such an issue with the EPPO. I'm a European citizen with fundamental rights. I'm the victim of a loss of confidence in the public institutions and their ability to defend general interests. So I filed a complaint to a Belgian court because of my Belgian interest, on grounds of my Belgian interest. Mrs. Ursula von der Leyen has powers delegated by the member states. The European states gave power to Mrs. von der Leyen. So she's a public office holder and she harmed Belgium and the Belgian citizens. So this is part of the competence of national court. But if we say that we have to transfer the case to the EPPO, which is supposed only to defend the interest of the institutions, well, what do? So it raises an issue of fundamental rights. It's difficult to answer that question with certainty because there should be a case-by-case approach. The EPPO is a European body which we have never used, and they have huge cases. I'm waiting to find out what the European prosecutor is going to say, because she has decided to take charge of this case because there were so many requests. Well, there was a press release saying, given the number of reporting that we got, we indicate to the general public that we are going to undertake an investigation. Didier Reynders, the Commissioner for Justice, was questioned about the activities of the EPPO. And in principle, the EPPO cannot deal with such a contract, such a huge contract, because the amount concerned is too high. So they're wondering what's happening, because they are saying in their press release that they are dealing with the case, but in their activity report, the amount of the contract cannot be included. So what's happening? Is it that there is no transparency? It becomes embarrassing.
There is another question. Stefano? Stefano, can you?
On va vous donner la parole, monsieur.
Stefano, you have the floor. If we can connect you. Maybe you can use the chat to ask your question.
So, hi, I will speak in English, if it's possible.
Oui.
You French. Yeah. So I'm Stefano Valentino. I'm a freelance journalist. I already had the chance to talk to député Rivasi sur le sujet des contrats des vaccins. J'ai une question, bon, je vais la poser en français vu que la majorité c'est des francophones, mais c'est une question qui s'adresse aux juristes.
So I have a question for the lawyers. I think there are lawyers in the room. So this is, so I would like to know if the contracts signed by the European Commission with Pfizer, you know, with authorization for the marketing of the Pfizer vaccine. So let's say if the authority, so European Marketing Authority did not renew this authorization, so does it mean that the contract with Pfizer is still valid? You know, if there was not a new authorization for, and this is a technical question, I would like to have the answer of the legal experts. Okay. So if I understood your question, you make the contract with the contract of Pfizer and the marketing authorization. So they were conditional, actually. And you're asking the question, if there was an obligation to renew this authorization. I'm sorry, I cannot answer this question. So if the marketing authorization was not renewed in 2022, does it mean that the contracts are still valid or not? Well, actually, currently there is a normal marketing authorization because all these studies have been done, you know, people were used as guinea pigs and tested, but I cannot answer that question, unfortunately. In the annex to the first contract signed in 2020, there is a annex which is making reference to the specificities of the vaccines, which Pfizer committed to. And I don't know if the next contract, if there was such an annex, because in the annex there was no reference made to the side effects of the vaccines, the dosage and the efficiency. If in the second contract the efficiency rate was higher. If actually my question is if there are annexed documents to the second contract, because you know we were talking about public health products. So my question is, can a contract be completely distinct from the scientific specificities of the product? Because so we say that after 14 days, the vaccine is still 90% efficient, and the marketing authorization authority has never made reference to all this information. So I would, you know, I wonder if the efficiency rate is lower than a certain percentage after a certain time. Can maybe the Commission use this argument to terminate contracts, and then the contract cannot be valid anymore? I don't know if from a legal point of view this is possible or not, to invoke such arguments. I have a few observations following your question. We were talking about transparency earlier on, and I can tell you that a lot of data were not disclosed by Pfizer. and they could actually be forced to provide this through the European agency, you know, that so the legislation was adopted to really as an exemption to the GMOs directive. So, but there was a precondition. Pfizer and the other laboratories, you know, had an obligation to do an environmental and toxicity study. So the EMA, the Marketing Authorization Authority, requested such a study but never received. So when you ask the question on the efficiency rate of the vaccine, well, you know, they were talking about 95% of efficiency, but all this information was provided only by Pfizer. Then later on, they said 3 months of immunity and you needed a second shot after 3 months. Well, I don't think I've ever seen any studies provided by independent scientific experts, because I would like to have independent scientists providing us with information on the efficiency of the vaccine and also the side effects. I can tell you that the committee, COVID committee, has asked also to have a more information, a survey on the side effects. And I remember Mr. Samo said the long COVID symptoms are well known. However, there has not been a study, an official study. I would like to have independent international scientists to provide us more information or a study on side effects. As just, you know, we are pretending there have not been side effects, because you remember Moderna, they were not vaccinating people under a certain age. AstraZeneca, you know, there were also risk of thrombosis and so on, and side effects on women. Well, there were, you know, scientists today said, oh no, there were no side effects, specific side effects. So things are not clear. And I think from a legal point of view, we should really ask if a lawyer, a legal expert challenging the information provided by the lab, could this actually be used as an argument to terminate the contract? Because we haven't, as I said in the beginning, access to all the information of the contract. But we haven't seen the full contract. But I don't think there is a clause on the guarantee of the efficiency of the vaccine. So the problem is that here, you know, we're not talking about being against or for vaccines. But I think we gave them a blank check without all the information. And I think today we need to have really concrete data from independent scientists to have information about the efficiency of that product. Because in the future, when we will be faced with another pandemic, we will go through the same problems. I am really a European, a true European. I defend Europe because I think Europe is the best way to protect us, you know, at international level, to fight climate change and all the other problems. But we need institutions, you know, which do really comply with the law. And we are going through a crisis. And today, actually, our last really means and possible defense is the justice system. But even here, in this case, we can see that the courts are really discussing who is competent. So I think it is important for us to really defend independent justice and the European public prosecutor. This is an appeal I'm launching to the European public prosecutor for a faster reaction. We cannot wait for the next mandate and the next parliament to take a decision. No, we need to really have an answer, because if we don't have an answer by 2020, really going to really discredit the institutions. So I think this is, it shows that money speaks. And once again, and someone former. So, you know, we could see the negotiators, among the negotiators, there were, you know, people who had a conflict of interest. And, you know, vaccines, actually, you know, there was no debate around vaccines. We could not say anything against vaccine. Otherwise, you know, we were you know, considered to be selfish and criticized. And actually, the labs are the ones providing all the studies and all the supporting document. They are the ones actually providing the information as far as the conflict of interest. Well, I think this is unacceptable when we're talking about European public health. And yes, here we're talking about the importance of lobby groups. And are lobby groups still really compatible with our democracy? And you know, there is so we just wonder, you know, as a MEP, you know, we are supposed to be transparent with the lobby groups, but we can see that you know, some civil servants sometimes are approached by the lobby groups and promise jobs in the future. I'm not, yeah, we cannot really call this corruption. However, it is a conflict of interest. And we cannot say today that all the scientists really, you know, are in a conflict of interest. And I think that actually this is what Christophe is showing, that there is really very often a conflict of interest between the different mandates of the scientists and the institutions. And I agree with you. We were hoping for the Commission to really make a proposal for setting up an independent ethics office. But no, you know, they want to put civil servants in such an office. We wanted experts, independent experts with the capacity to really take sanctions. The institutions really must be accountable, and if people come from the private sector to the institutions, you know, they must be of irreproachable quality. Well, we have to conclude. Thank you very much for your questions. Thank you very much for attending this meeting. As you can see, this is a topic which goes well beyond the case of this pandemic. But I think we should seize this opportunity to really ask for more consolidation of or institutions' transparency, and also to adopt sanctions, because the concept name and shame is not enough. And today we need independent bodies. People must be made accountable. People, private citizens, if they don't pay their taxes, they will be made accountable. And yes, and the agencies, we can see that the agencies are making recommendations, but if the people sitting in these agencies emanate from the industry, the COVID committee, so you have taken a decision or requested a decision to really prohibit the Pfizer to really have access to the institutions, but the parliament did not follow your recommendation. So you can see there is a problem of really controlling the power of the lobby groups. And actually, we do not have a legislation like the American one. People are not forced to declare the meetings they have or their interests. So, in the US, there is really a legislation, a very strict legislation to prevent this conflict of interest. But in Europe, in the European Union, so there are no sanctions. When people are not transparent, there is conflict of interest. So how can people really make their work without really being influenced by all these lobby groups? And there are no sanctions taken. But I can tell you, on the other hand, the lobby take countermeasures against us. Thank you very much for attending this meeting. And my hope is that we will, I hope, strengthen our institutions and consolidate the legislation. And I hope for independent scientists to really take the decisions and present the results. Thank you very much for your attendance.